No, it's not legal aid believe that the chances of success are slim. Legal aid, it says to the applicant that yes, they can apply for Section 174. We agree with you. However, the issue of contention, it was an issue of an increased fee, which we said that we cannot grant you an increased fee. Insofar as the prospect of the success of Section 174, that one, it is determined by the presiding officer and the applicant.
Okay, wait a minute. You guys know the last day court was in session. It was all about Section 174 and legal aid. And that is where we found out from not only Ramasipili and advocate Mnisi Wemvula that there's issues in the background. Legal aid came back and said, no, we are not paying. Then Ramasipili said they specifically said they do not see there's any prospects of you winning. So why would we want to pay for legal aid? And that is what we left the courtroom thinking. Now, what Mr. Legal Aid has come forward and given an interview to explain the whole thing. And let me tell you something, spoiler alert, his explanation is completely different from what we heard in court. Remember, in court, there was also the legal aid lady who also came to explain to the judge, because the judge, I guess, wanted to hear it for himself because he couldn't believe that legal aid was refusing to pay for Section 174. Well, guess what? Mr. Legal Aid now is saying no, 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 no. Is legal aid literally backtracking on the words that we heard in court on recording? Let me know what you think. But Mr. Legal Aid is saying, nope, that's not what we said. The attorneys and advocates, they came to us and asked for an increased tariff. And we said no to the increased tariff. That's not what we heard in court. But anyway, before I break into my feedback, let's continue listening. Maybe he gets clearer down the line.
Yes, they can apply. They know it's within the right of the legal practitioner and the client to apply for 174.
Yes, so essentially what they are saying is that um, this is an information that they received from you that particularly accused number two's lawyer saying that the exact words used are, they say we have no leg to stand on.
Yes, what we said to them to inform the accused and also legal representative when they apply on behalf of their client, we inform that look, one thing that legal aid do, we give you instruction, and the instruction is in terms of the prescribed tariffs. And in terms of the prescribed tariff, 174 is a part of the application. And when you come before us and apply for increased fee and to the special fee for that which is not covered by our tariffs, then we have to, or even if where you want increased fee, we had to check and determine the merits of the application that you are sending to us, whether that is there any prospect here in this regard. And in that case, when we were checking and assessing that, we said that to them, yes, your client believe that there is a prospect in this, but we don't deny that. We don't want to get into the fray of whether there's a prospect or what. What we can say to you, can apply for 174, but the prospect in terms of applying for increased fee for the records that you have already read, we cannot grant you increased fee. We are declining, but it's your opportunity to go there and apply for Section 174. But you must know that this 174 that you are applying, we are going to pay you in terms of the tariff, and we are not going to put any increased fee on that or any preparation fee to stay home maybe for 2 weeks or 1 week or 4 weeks to prepare. We are not going to fund it.
Again, disclaimer, I don't know if legal aid is backtracking, but from what he said, he says they have this graph, okay? And then when they have these advocates and attorneys who are part of their legal aid system and approved to be their attorneys, and they approach them and there's a case, they say, okay, this is the deal. This is how much we're going to pay you. This is what we're going to pay you in discovery. This is what we're going to pay you during trial days. And then each trial day you get 2 hours preparation. And this is all negotiated ahead of time. Of course, they've no way of knowing how long the trial will last. So that's not part of the negotiations. So what he is saying here is that the defense team came back to legal aid and said, we are about to do Section 174. Listen, there's a lot of work involved with that. We need an increase. And legal aid says, nope, we already gave you the budget and it does not include you coming back to ask for extra time or extra money. So when they say an increased tariff, to me, my understanding is that above and beyond what they agreed to pay them. And so because they're asking to be home for 4 weeks and paid, legal aid said, nope, that was not in the initial negotiations. You've been in trial. We've been paying you. You should be able to do the Section 174. We are not preventing you from doing Section 174. In fact, there's no way that we legal aid can know the standings of the case. If so, that we didn't say that. So they are disputing what Ramasipili said, legal aid said. They're saying, nope, we did not say that. We said we're not going to pay you. Two different WhatsApp groups. Let me know, is that what you're understanding from this interview?
So does it then mean that legal aid, in as much as you say you are not going into the merits of whether or not the application itself will succeed, does it then mean that you also do not monitor the case? Because monitoring the case would have direct impact on the funds.
Yes, we monitor the case from time to time. That's why there's an application for increased fee. Because if they apply, we are checking, we are monitoring how far is the case, and whether if there is this thing, whatever process which they've applying for, whether that we can grant them that we can do that. Like, for example, if they say we want to apply for leave to appeal, maybe after the finalization, then that's when then we can check the whole record and check as to whether there's a prospect of success. But insofar as Section 174 is concerned now, already we have granted them that do the trial, and a part of the trial, it is a Section 174, but not for them to come to us and say, we want preparation fee, we want a special fee for Section 174. Then that one we say, no, we are not going to grant you. But monitoring, we monitor it. That's why we can know that how much we've paid them for. And there were some other applications which were made, and some of them we refused, we did not accede to.
So again, it sounds like the defense team was trying to renegotiate their original contract and now trying to get an increase so that they could be paid separately in this increase for Section 174. But legal aid is saying, no, there's nothing special about Section 174. It's part of the trial. We know that it's going to happen. It's a possibility. It's an option. It's in the Constitution. So it's in the criminal code. So it is definitely something that is included. So when they do disclosure, when they do all that, all those things, it's part of it, which also including if at the end of the trial they decide to do an appeal of whatever the judge's decision is, that is all included in whatever current fee they're being charged, whatever tariff it is. They can't just now suddenly ask for more.
Firstly, let me start here. We have the tariffs at the Legal Aid South Africa. And the practitioners, they come to us, if they are accredited with us, they are on our database accredited. When there is a matter which they have to, we grant them a matter, we give them something called LA2. In that LA2, there are all terms and also of the agreement. How are we going to conduct ourselves, and also how are you going to deal? And then we also inform them about the prescribed tariffs, that these are the tariffs which are applicable. The tariffs, there are two components. Let me come specifically to this matter. In this matter, there's a tariff, and one first part of tariff, there's a preparation, pre-trial, before trial starts. In that pre-trial preparation, a person, we give him that you can prepare for a certain number of hours, which is maybe 8 hours, and others, then they can. And then 8 hours preparation fee, that's what we are giving you, and you peruse, and you give you a certain amount that per hour, this is how much we are going to pay you. So a person can stay maybe at home and then stay for 1 month, like in the case of Mr. Mnisi, stay for 4 months because he was having additional accused number one. Accused number one, he was entitled to pre-trial because he was dealing with another attorney. Now we are giving him this. Now he was entitled. We gave him that increased fee and also pre-trial preparation. And the invoice that which he submitted, those invoices were paid in terms of our agreement.
Why is this turning into a case of he said, she said? Now we need to see the invoices to see what is going on. Now, the key word that I heard him say is the invoice that Mnisi submitted, they have paid it according to their agreement. And I'm imagining agreement at the very beginning of the trial, which is whatever the rate is, no premium, no additional, no dun-dunis. So this is very interesting. But on the other hand, Mnisi in court, when asked by Judge Rata, were you paid? He said, that is a painful story. I don't want to talk about it. So it looks like the left hand and the right hand are not in agreement. They are not working hand in hand. What is going on with legal aid and the defense team? Because legal aid is out here giving media interviews and singing a very different story from the song that Miss Legal Aid inside the court was singing the other day. Complete night and day, complete difference. So is this damage control? Let me know your thoughts in the comment section down below. You already know. There's more, right? Yeah. There is still a lot more to uncover.
Then the second issue of preparation, it's in trial. When there's a trial process are running. Now this time, because remember you had a pre-trial preparation, we paid for those things. Now when you say it's like something refresh, we say we can give you a maximum of 2 hours in trial. When the trial proceeding, we first accuse, and then we'll give you additional, again, an hour for the second accused and the third accused. So you can then consult, refresh yourself there, and then you can claim there. But that provides, it must happen while the matter, it is still in court and the matter is proceeding. We can't give you that when you are not at home and the matter is not proceeding. That's why we call in-trial preparation fee. And we have made that in this case because 174 is a part of the whole criminal proceeding. It's just a stage in a criminal proceeding. Like in case of a trial within a trial, section 174, mitigation of sentence, it's a part of trial. So there's no special tariff for that you must prepare for every stage of the criminal proceeding. Increased tariff, we give you increased tariff on a semi-complex matter and then also on complex matter. And they don't go, they differ from the percentage as well. If it is a very complex matter, then we give you the maximum tariff also that we are going to pay you in terms of this. And in this matter of a SENZO MEYIWA case, they've applied before the issue of on the 7th. The practitioner applied for increased fee and they justify the number of documentation, the matter starting de novo, they have to read the whole records and also they had to read the other statement.
So this was at the beginning of the trial?
Yes, at the beginning of the trial when they were applying for the increased fee at that time. And then we said, yes, it's justified the volume of the matter to the documentation to prepare. They must go through the record, all of the records they are going to start with, and then we give them the increased fee based on that, and also this type of matter. And also, again, taking into account, remember when this matter, when they were coming at Legal Aid South Africa, there were some of the accused, they were private accused, which they were funding their own legal representative. So in order not to delay the matter, then the legal aid were also, they apply, they say, we want funding, and also this matter start, legal aid can come in, then they apply, and we found that they qualify because all of them, they are in custody. They don't have a source of means of income. Then they qualify. And then we take over the practitioner who were doing the very same bit, and then they've applied for increased fee after that, and then they were granted that increased fee.
So
and the second bite of increased fee again, it was Mr. Mnisi again when he gets accused number 1, where after Mr. Mgemezulu passed on, may his soul rest in peace. Then we granted him increased fee that we can give increased fee and that and read all those documents when we were saying there are 40,000 documentation.
Again, legal aid says they paid Mnisi Wemvula. Mnisi in court is saying he hates the narrative that he is trying to get more money out of the system. So it looks like there might have been a lot of back and forth around this. So Mnisi was paid, according to legal aid, that's the summary I'm getting. He was paid for reading the 60,000 pages. And then now when it comes to requesting 4 weeks to do the preparation for Section 174, legal aid is saying, oh, no, absolutely not. Because that is not a separate fee structure. It's included in the original fee structure that we agreed upon. So you should be able to prepare for the Section 174 because we give you 2 hours when the trial is in session. You can use that time to prepare for your Section 174. I mean, you've been there a while. Is this a case of they think that not a lot of time is needed to prepare for a Section 174 and that 2 hours a day is enough? Let me know in the comment section down below.
Yes, it's translated to that. If you request more hours on increased fee, now we give you additional amount because in a way it also falling under our tariffs. It's an increased fee because now we are deviating from prescribed tariff. we are giving you in terms of because remember, for every rule, there's an exception where we say, under this special circumstances, which are exceptional, we can deviate and then we give you this increase fee, which are there in terms of our tariffs. And the tariffs prescribe how can we do the increase fee and what must we look and how, in what instances we can give increase fee. So in this instance, one, already they have read the record. There was a pre-trial, we gave them the fee. Secondly, for accused number 1 and 2, he came again for accused number 1, and then he get again the fee to prepare for those months again. The same record, same everything. So that for this time now again, it will be again increased for the third time on same records and on same documentation, which are before court and the same evidence. When it came before CCMC, it did not pass the test. That the CCMC, then they found that it is not justified, and also this cannot qualify to give them this additional fee. And that's how the application was declined. And they said, no, we are not going to grant this application.
So far, I know you had previously released the figures and the amount of money that you had already spent, which is in excess of 6 million rand. What is the updated figure in this particular matter?
Yeah, the updated figure for now, I'm not, but the one which we released last time, it was 6 point, like you are indicating now. But we will have to check whether they've then submitted their invoice and everything, those figures. But the figures, yes, definitely it will be slightly more than the previous one when we're indicating now. But what we are happy about is that we have at least now have passed the stage of the state case. Now we are at the stage of a defense case, where now the defense now has to present its case, apply for 174 first, and then we'll hear from the presiding officer what is his verdict on 174, and then the matter goes to defense. So we are happy now this matter has passed the period where it was on the state case.
This one, I'm going to leave it to you to let me know in the comment section what you understood about this video. Was Mnisi paid or not paid? Why did Mnisi in the court give an indication that he wasn't paid? Or is it that he was paid but a lower rate or reduced hours? What could it possibly be? In my interpretation, I feel that at this point, legal aid, I think it's a timing issue. As he said, they do exceptions. So Mnisi had just come back from, I think it was about 4 months, where they paid him, according to what they're saying, where they paid him. So therefore, he was reading the record most recently, and now he's asking for an additional time. What do you need additional time for to go back to the record, which you just read? You should be able to do the section 174 without going back with extra time. You can utilize the 2 hours that we give you per day while court is in session. Is it fair? I want to hear from you in the comment section down below. Thanks so much for watching. You already know, like, comment, and subscribe. I'll catch you, of course, on my next upload. Bye.